Regulation of the Board of Directors of Auricoin Banks. Welcome to Auricoin's channel. Today I present you the regulations that will govern the Administrative Council of Auricoin's virtual banks. At Auricoin, we promote the best international corporate governance practices for Auricoin banking, with the purpose that they are prepared to be listed in the main stock exchanges of the world. We follow the best international practices in corporate governance. All the governing bodies in each country where a bank of Auricoin is installed will be conformed by professionals who must have ample experience and knowledge of banking administration, securities, cryptocurrency, money, and blockchain technology. The highest governing body of a bank that is assigned through a franchise will be the General Assembly of Members, who has the power to designate the members of the Board of Directors. According to the bylaws of Auricoin Bank in each country, the Board of Directors must be composed of 15 directors, of which 51% must be independent. The Board of Directors will be the governing body in charge of establishing the long-term business strategy, approving the main business decisions, supervising the administration, managing risks, monitoring regulatory compliance, as well as electing, evaluating, and removing the general manager and relevant executives of Auricoin Bank. The concern to create value in virtual banks Auricoin is included and was taken very seriously, the establishment of good administrative practices through corporate governance. Greater transparency about the way in which Auricoin banks carry out their work and with strong governing bodies are two elements that are highly valued by any investor. This creation of value in the Auricoin banks is given inwardly with an administration that becomes more efficient every day. Resources will be better used and labor policies become fairer. This translates into greater competitiveness and better financial performance. Therefore, it translates into greater profitability. When there are mechanisms for supervision and participation of shareholders, having a professional board of directors, a dynamic of constant search for growth develops. This allows defining plans and verifying the fulfillment of the objectives and goals. In addition, this, in turn, generates greater confidence in the market and potential investors. With good corporate governance in Auricoin banks, risk management also improves. The search for balance between internal objectives and shareholders' objectives means that Auricoin banks are closely observing the market and their own businesses and working with longer-term goals. Banks with a long-term vision also generate trust among other stakeholders. Ultimately, this translates to reputation and recognition. 100% of the value of Auricoin banks are intangible, and it has to do with that reputation. It is a great honor for me to present you the regulation of the Board of Directors of the Auricoin banks. Title 1. Preliminary. Article 1. Object and Purpose. 1. This regulation will serve as a guideline to be assumed by the franchise awardees to take the administration of Auricoin Bank in the country where they install it. 2. The purpose of these regulations is to determine the principles of action of the Board of Directors, the basic rules of its organization and operation, and the rules of conduct of its administrators. The regulation aims to achieve greater transparency, efficiency, impulse, supervision, and control in its management, functions, and representation of social interests, in accordance with the principles and recommendations on corporate governance. Article 2. Scope of application. 1. These regulations are applicable to the senior managers of Auricoin Bank and to the extent that it is compatible with their specific nature and the activities carried out by the members of the management team of Auricoin Bank. For the purposes of these regulations, the term management team shall be understood as the director, deputy director, regional executives, managers, account executives, advisor, delegate, delegated committees, and all those people who are directly dependent on the board of directors. 2. The people to whom this regulation is applicable will have an obligation to know it, comply with it, and enforce it. For this purpose, the Secretary of the Board will provide all of them with a copy of the same, without prejudice to its publication on the official website of Auricoin Bank in the corresponding country. Article 3. Prevalence and interpretation. These regulations develop and complete the legal and statutory regulations applicable to the Board of Directors of an Auricoin Bank. 1. These regulations will be interpreted in accordance with the principle of normative hierarchy and in accordance with the statutory regulations that are applicable, as well as with the principles and recommendations of corporate governance. 2. The Board of Directors, following a report from the Appointments and Remuneration Committee, will resolve any doubts of divergences that may arise in the application or interpretation of these regulations. Article 4. Dissemination and modification. 1. The Board of Directors will adopt the necessary measures to disseminate these regulations among the executives and the general public, in particular and without prejudice to other possible measures. The regulations will be communicated to the executives. The regulations will be available on the website of Auricoin Bank in each country. 2. The regulations may be subject to modification at the proposal of 3 advisors, the Appointments and Remuneration Committee of the Audit and Compliance Committee. Modification proposals must be accompanied by a supporting report and be informed by the Appointments and Remuneration Committees, except when the proposal has been made by the latter. The text of the proposal, the supporting report, and, where appropriate, the report of the Appointments and Remuneration Committee must be attached to the minutes of the meeting of the Board of Directors that is to deliberate on it, in whose agenda it must be expressly stated. 3. The modification of the regulation must be approved by means of a resolution adopted by 50% plus 1 vote of the members of the Board of Directors attending the meeting, provided that the favorable vote of the majority of the independent advisors is also obtained. Title 2. Mission of the Board. Article 5. Powers of the Board of Directors. 1. The Board of Directors is competent to adopt resolutions of all kinds of matters. 2. The Board of Directors is responsible for the broadest powers and faculties to manage, direct, administer, and represent Auricoin Bank. As a general rule, it will entrust the ordinary management of Auricoin Bank to delegated administration bodies. It will concentrate its activity on the general supervision function and on the consideration of those matters of particular importance for Auricoin Bank. 3. The representation of Auricoin Bank in each country corresponds to the director and outside it to the Board of Directors, its advisors, the Chief Executive Officer, if appointed, and the delegated committees. In any case, the Board of Directors will assume those powers legally or statutorily reserved for its direct knowledge with a non-delegable character, as well as those others necessary for the effective exercise of the general supervisory function. In particular, by way of example and not limitation, the following are non-delegable powers of the Board of Directors. A. The approval of the general policies and strategies of Auricoin Bank requires their implementation, including, among others, the following. 1. The strategic or business plan, as well as the management objectives and the annual budget. 2. The investment and financing policy. 3. The definition of the structure and the coordination of the general strategy in the interest of Auricoin Bank. 4. The corporate governance policy of Auricoin Bank. 5. The corporate social responsibility policy. 6. The supervision of the operation of the committees that have been constituted within them, as well as the performance of the delegated bodies and the managers that have been appointed. 7. The remuneration policy and evaluation of the performance of the members. 8. The risk control and management policy, the supervision of the information and control systems, identifying the main risks of Auricoin Bank and organizing the appropriate internal control and information systems. 9. The definition of the basis of the corporate organization in order to guarantee the best efficiency of the same and the effective supervision by the Board of Directors. And 10. The establishment and implementation of dividend and treasury stock policies within the framework of the authorizations of the General Assembly of Members. B. The approval of the following operational decisions. 1. The convocation of the General Assembly of Members, the elaboration of the agenda and the proposed resolutions. 2. The appointment of directors by co-option and the submission of proposals to the General Assembly of Members regarding the appointment, ratification, re-election, or removal of directors, as well as the acceptance of the resignation of directors. 3. The appointment and renewal of the internal positions of the Board of Directors and of the members and positions of the committees set up within the Board of Directors. 4. The delegation of powers to any of its members in the terms established in these statutes, as well as their revocation. 5. The appointment and removal of the CEOs of Auricoin Bank and the managers who report directly to the Board of Directors, as well as the establishment of the basis conditions of their contracts, including their remuneration. 6. The authorization or waiver of the obligations derived from the duty of loyalty when it corresponds legally to the Board of Directors and in accordance with the legal provisions. 7. The formulation of the annual accounts, the management report, and the proposal for the application of the results of Auricoin Bank, as well as the annual accounts and the consolidated management report and their presentation for the approval of the General Assembly of Members. 8. The approval of the financial information that, due to its conditions, Auricoin Bank must periodically make public. 9. Preparation of the annual report on corporate governance and the annual report on directors' remuneration for presentation to the General Assembly of Members and the other reports and documents that must be submitted to it. 10. The approval and modification of this regulation. 11. The proposal to the General Assembly of Members of Auricoin Bank of the modifications of the regulations of the General Assembly of Members, which it deems appropriate to guarantee the exercise of their participation rights of the members. 12. Decisions regarding the remuneration of directors within the statutory framework and, where appropriate, the remuneration policy approved by the General Assembly of Members. 13. The setting, in the case of executive directors, of any additional remuneration for their executive functions and other conditions that their contracts must respect. 14. The establishment of strategic alliances with industrial, commercial, or financial groups anywhere in the world. 15. Investments, divestments, or operations of all kinds, including financing operations that, due to their high amount or special characteristics, have a strategic nature or special risk, among which are industrial, commercial, or financial operations of special relevance, except that 1. Have been approved in the annual budget, or 2. Their approval corresponds to the General Assembly of Members. 16. The creation or acquisition of shares in special purpose entities or domiciled in countries or territories that are considered tax havens, as well as any other transactions or operations of a similar nature that, due to their complexity, could undermine the transparency of Auricoin Bank, prior report of the Audit and Compliance Committee. 17. Those powers that the General Assembly of Members have delegated to the Board, unless it had been expressly authorized by it to subdelegate them. 18. The formulation of any kind of report, when the operation to which the report refers cannot be delegated. C. The approval of the operations that Auricoin Bank carries out with directors under the legally established terms, or with members who hold individually or in concert with others a significant participation, including members represented on the board of directors of Auricoin Bank or vinculated operations, the directors affected or who represent or are linked to the affected members must refrain from participating in the deliberation and voting of the resolution in question. However, the authorization of the board will not be required for those related party transactions that simultaneously meet the following 3 conditions. 1. That they are carried out by virtue of contracts whose conditions are standardized and are applied en masse to a high number of clients. 2. That they are carried out at market prices or rates set in general by whoever acts as the supplier of the good or service in question. 3. That the amount of the operation does not exceed 1% of the annual income of Auricoin Bank in the country that is installed. 4. When there are duly justified urgent circumstances, the decisions corresponding to the above matters may be adopted within the powers mentioned in letters B and C by the delegated bodies or persons, which must be ratified at the first assembly of the Board of Directors that is held after the adoption of the corresponding decision. Article 6. Evaluation of the Board of Directors and its committees. 1. The Board, as responsible for the corporate governance policy, will evaluate once a year the quality and efficiency of the operation of the Board in general, the performance of the direct functions of the Board and the Director, the operation and composition of its committees, the diversity in the composition and powers of the Board, the performance and contribution of each Director, with special attention to the heads of the different committees. 2. For the evaluation of the different committees, it will be based on the reports that they submit to the Board, and for the evaluation of the Board, from the reports submitted by the Appointments and Remuneration Committee. 3. Based on the results of the evaluations, the Council will adopt an action plan to correct the deficiencies detected. Article 7. Social interest. 1. The Board of Directors, in the performance of its functions, will always pursue the social interest of Auricoin Bank, understanding by such the achievement of a profitable and sustainable business in the long term that promotes its continuity and maximization of the economic value of Auricoin Bank. Considering that at the same time the other legitimate public or private interests which converge in the development of their business activity, especially those of the partners, suppliers, clients, and other interest groups. 2. Likewise, the Board of Directors shall ensure that in its relations with stakeholders linked to Auricoin Bank, it respects these regulations and its behavior is at all times based on good faith, ethics, respect for the uses and good practices of the sectors and territories in which it carries out its activity, and observes those additional principles of social responsibility that it has voluntarily accepted. Title 3. Composition of the Board. Article 8. Number of Directors. 1. The Board of Directors will be made up of the number of directors determined by the General Assembly of Members within the limits set by the bylaws. 2. It is the responsibility of the General Assembly of Members to determine the number of directors. The General Shareholders' Meeting may proceed to fix the same by express agreement or indirectly through the agreements for the provision of vacancies and the appointment of new directors that it adopts within the statutory limits. 3. The Board will propose to the General Assembly of Members the number of directors that, depending on the circumstances at any given time, is more appropriate to ensure the proper representation and effective functioning of the body. Article 9. Categories of Directors. 1. They will be considered as A. Executive Directors, the directors who perform management functions in Auricoin Bank or in its group, whatever the legal relationship they maintain with it. For these purposes, the director will be considered as executive directors. In the event of having executive functions delegated, the Chief Executive Officer, if any, and those who by any other title carry out management responsibilities within Auricoin Bank or others that depend on it. However, the directors who are senior managers. When a director performs management functions and at the same time is or represents a significant shareholder who is represented on the Board of Directors of Auricoin Bank, he will be considered an executive. B. External proprietary directors, directors who have a shareholding greater than or equal to what is legally considered significant or who have been appointed by virtue of their statutes as partners, even though their shareholding does not reach said amount, as well as those who represent said partners. C. Independent external directors, the directors who, appointed in the consideration of their personal and professional conditions, can perform their duties without being conditioned by relationships with Auricoin Bank, its significant partners, on their executives who meet the legal requirements and conditions that are required to such effect. D. Other external directors are external directors who cannot be classified as proprietary or independent. 2. The nature of each director will be explained by the Board of Directors before the General Assembly of Members that must make or ratify their appointment, and will be confirmed or, where appropriate, reviewed annually in the annual Corporate Governance Report after verification by the Appointments and Remuneration. Article 10. Composition of the Board of Directors. 1. The Board of Directors, in the exercise of its powers to propose to the General Assembly of Members and to co-opt for the filling of vacancies, will ensure that in the composition of this body, the non-executive external directors represent a large majority in the board in particular, so that the number of independent directors represents at least between half and a third of the total number of directors, taking into account the capitalization of Auricoin Bank and the number of significant associates who individually or with the board control more than 51% of the share capital. 2. The board will also ensure that within the external directors, the ratio of proprietary directors over the total of non-executive directors reflects the existing proportion between the capital of Auricoin Bank represented by the proprietary directors and the rest of the capital. 3. The strict proportionality criterion between proprietary directors over the total number of non-executive directors might be attenuated so that the weight of the former is greater than the corresponding to the total percentage of capital they represent. In the event that in Auricoin Bank 1. there are few holdings that are considered significant, or 2. there is a plurality of members represented on the board and they have no links between them. 4. In the event that the board of directors appoints or proposes the appointment of proprietary directors at the request of partners whose shareholding is less than 3%, it must explain the reasons for this in the annual corporate governance report. Likewise, it must state the reasons why formal requests for a presence on the board from members whose shareholding is equal to or greater than that of others at whose request proprietary directors have been appointed have not been addressed. Title 4. Structure of the Board of Directors. Article 11. The Director of the Board. 1. The Director of the Board of Directors will be elected from among its members after a favorable report from the Appointments and Remuneration Committee, will have the powers provided for in the law or the corresponding country in the bylaws in these regulations, as well as those that, if applicable, the Council itself entrusts. 2. In particular, the following powers will correspond to the Director. A. The ordinary power to call and preside over the meetings of the Board of Directors, to form the agenda and to direct its meetings. B. Preside over the General Assembly of members, direct the discussions and deliberations of the same. And C. Exercising the high representation of Auricoin Bank before public bodies and any sector or employer bodies. 3. Likewise, the Director, as responsible for the effective functioning of the Board, will ensure that the Directors receive sufficient information prior to holding a meeting and will endeavor to stimulate debate and the active participation of the Directors during the Board sessions. Safeguarding his free position and expression of opinion, he will organize and coordinate with the Director of the Appointments and Remuneration Committee the periodic evaluation of the Board, as well as that of the CEO or Chief Executive where appropriate. Similarly, the Director shall prepare and submit to the Board a schedule of dates and issues to be addressed, ensure that sufficient discussion time is devoted to strategic issues, agree upon and review refresher programs for directors when circumstances warrant. 4. An executive director may hold the position of director of the Board of Directors. In this case, the appointment of the director will require the favorable vote of 2/3 of the members of the Board of Directors. 5. In the event that the director meets at the same time the condition of CEO or Auricoin Bank, the Board of Directors with the abstention of the executive directors, will appoint a coordinating director from among the independent directors at the proposal of the Appointments Committee and Remuneration, which will specially empowered to request the director to call the board of directors, the inclusion of new items of the agenda of a board that has already been convened, to coordinate and bring together the external directors and to direct the periodic evaluation of the director. Likewise, the coordination director will be empowered to preside over the board or directors in the absence of the director and vice directors, if any. Echo the concerns of non-executive directors. Maintain contacts with investors and partners to know their points of view in order to form an opinion on their concerns, in particular in relation to the corporate governance of Auricoin, and coordinate the succession plan of the director. Article 12. The Vice Director. 1. The Board, after a favorable report from the Appointments and Remuneration Committee, must necessarily designate a Vice Director who will replace the Director in case of impossibility or absence. 2. The Council may also appoint other Vice Directors, in which case the functions described will fall to the first Vice Director, who in turn will be replaced in case of need by the second Vice Director, and so on, and if there are no Vice Directors, by the Director with the highest seniority in the appointment, in case of equal seniority by the oldest. Article 13. The Secretary of the Board. 1. The Board of Directors will elect a Secretary, whose appointment may fall to one of its members or to a person outside the Board with the ability to perform the functions of said position. In the event that the Secretary of the Board of Directors does not meet the equality of director, he/she will have a voice, but no vote. 2. When the Secretary simultaneously occupies the position of lawyer advisor, his appointment must fall to a legal professional. 3. In addition to the functions assigned by the law and the bylaws, the following shall correspond to the Secretary of the Board of Directors. A. Safeguard the social documentation, duly reflect in the minute books the development of the sessions and attest to the agreements for the different entities of the state. B. Take care of the formal and material legality of the actions of the Board of Directors and its delegated bodies, checking that they comply with the letter and spirit of the laws and the regulations, including those approved by regulatory bodies, as well as ensuring compliance of the rules of the bylaws. These regulations, the board regulations, and other internal rules and regulations of Auricoin Bank, with special attention that in its actions and decisions the board takes into account the recommendations on good governance in the corresponding country. C. Assist the director so that the directors receive the relevant information for the exercise of their function with sufficient notice and in the appropriate format. D. Check compliance with the recommendations of good corporate governance that Auricoin Bank has accepted. E. Generally channel the relations of Auricoin Bank with the directors in everything related to the operation of the Board of Directors, in accordance with the instructions of the director. F. Process the request of the directors regarding the information and documentation of those matters that correspond to the Board of Directors. G. Any others that may be attributed to the Board of Directors. 4. The Secretary will be appointed and re-elected, as the case may be, dismissed by the full Board, following a report from the Appointments and Remuneration Committee. Article 14. The Deputy Secretary of the Board. 1. The Board of Directors, after a favorable report from the Appointments and Remuneration Committee, may appoint a Deputy Secretary who does not need to be a director to assist the Secretary of the Board of Directors or replace him in the event of absence in the performance of such function by any reasons. 2. When the Deputy Secretary simultaneously occupies the position of lawyer advisor, his appointment must fall to a legal professional. Article 15. Delegated bodies of the Board of Directors. 1. In accordance with the provisions of the Articles of Association and without prejudice to any delegation of powers made individually to the Director, the Chief Executive Officer, or any other Director, the Board of Directors may appoint from among its members an Executive Committee, to which it may delegate in whole or in part, temporarily or permanently, all the powers that cannot be legally delegated and with the limitations for internal purposes, resulting from Article 5. If an executive committee is set up, the board will designate its members, ensuring that the structure of participation of the different categories of directors is similar to that of the board itself, and the secretary of the committee will be the secretary of the board. 2. The board of directors will appoint from its midst an audit and compliance committee and an appointments and remuneration committee, which will be governed by the provisions of the law, the statutes and these regulations of the Board of Directors of Auricoin Bank, in all matters not specifically provided for in the foregoing. The operating rules established by these regulations in relation to the board shall apply, provided by are compatible with the nature and function of the corresponding committee. 3. Likewise, the Board of Directors may set up other committees made up of directors with the functions it deems appropriate. Title 5. Functioning of the Board. Article 16. Meetings of the Board. 1. The Board of Directors will meet as many times as deemed appropriate by the Director for the proper functioning of Auricoin Bank and for the proper performance of its functions, in any case at least once a quarter. 2. The Board of Directors will set the calendar of the ordinary sessions before the beginning of each fiscal year. 3. In any case, the Board must necessarily meet within a maximum period of 3 months from the close of the fiscal year in order to formulate the annual accounts, the management report, and the proposal for the application of the results. 4. The call for the sessions will be made to each director by letter or email and will be authorized with the signature of the director, or where appropriate, that of the secretary or vice secretary by order of the director. The call will be made at least 5 days in advance, unless there are urgent reasons and the director calls it 48 hours in advance. Likewise, the call will always include the place, date, and time of the meeting, the agenda for the session, and will be accompanied, where appropriate, by the information deemed necessary. The agenda will clearly indicate those points on which the Council must adopt a decision or agreement. 5. The Board of Directors will also meet when requested by at least 1/3 of its members, 2 of the independent directors or the lead director, in which case it must be convened by order of the director or lead director, depending on the case. Any director shall have the right to require the director to include certain matters in the call for any board meeting, without prejudice to the power of proposal that corresponds to each director. 6. Likewise, the directors who constitute at least 1/3 of the members of the board may summon it, indicating the agenda, to be held in the town where the registered office is located, without prior request to the director, who without just cause would not have made the call within a month. 7. In the event that the director meets at the same time the condition of CEO of Auricoin Bank, the board of directors, with the abstention of the executive directors, will appoint a coordinating director from among the independent directors at the proposal of the committee or appointments and remuneration, which will be especially empowered to request the director to convene the board of directors or the inclusion of new items in the agenda when deemed appropriate. 8. Notwithstanding the foregoing, the board shall be understood to be validly constituted without the need for a call when all the directors being present or represented unanimously accept the holding of the meeting as universal and the matters to be discussed at the same. 9. If no director opposes these, the board may also adopt resolutions in writing without the need to hold a meeting, in accordance with the provisions of the law and the bylaws, in which case the vote may be cast in writing or by mail, always that the identity of the director who issues it is assured. 10. Technical experts, both internal to Auricoin Bank and external, may attend the board sessions as guests to provide assistance to the directors when the director of the board of directors deems it necessary. Article 17. Place of celebration. 1. The meetings of the board and its committees will be held at the registered office of Auricoin Bank or in the place within the country of its legal domicile or abroad, which is indicated in the call. 2. Notwithstanding the foregoing, the meetings of the board and its committees may be held using remote communication means if any of its members is unable to attend the place set for the meeting in the notice, and provided that in the director's opinion there are no circumstances that make it inadvisable. 3. Directors who do not physically attend the place of the meeting and who use means of communication that allow the meeting to take place simultaneously and reciprocally with the place of the meeting and with the other members who use means of distance communications shall be considered as attending for all purposes and may cast their vote through the means of communication used. Article 18. Conduct of meetings and adoption of resolutions. 1. In order for the agreements within the competence of the Board of Directors to be valid, it will be necessary for the meetings at which they are adopted to be attended between those present and those represented by the majority of the members of the Board. 2. The directors must attend the meetings of the Board, so absences will be reduced to the indispensable cases. When they cannot attend in person, they shall try to grant their representation in writing and on a special basis for each meeting to another member of the board and, as far as possible, with instructions. Independent directors may only grant their proxy to another independent director, and non-executive directors may only grant their proxy to another non-executive director. Proxies may be granted by any postal or electronic means, provided that the identity of the director and the meaning of the instructions are assured. 3. The director shall organize the discussion by seeking and promoting the participation of all board members in the deliberation of the organ. When, for reasons of urgency, the director submits decisions or agreements that are not on the agenda for the approval of the board, the prior and express consent of the majority of the directors present will be required, which will be duly recorded in the minutes. 4. The directors and, where appropriate, the secretary must clearly express their opposition when they consider that any proposed decision submitted to the board may be contrary to the corporate interest. They will do the same, particularly the independent directors and other directors who are not affected by the conflict of interest, when dealing with decisions that may harm the members not represented on the board. 5. Except in cases where the law or the bylaws specifically establish other voting quorums, the resolutions will be adopted by an absolute majority of the concurrent directors present or represented at the meeting. In the event of a tie in the voting, the director's vote will not be casting. 6. The secretary, who will be signed at least by the director or the vice director if applicable, and the secretary or vice secretary, as the case may be, will draw up minutes of the meetings of the board of directors. The minutes will be transcribed or collected in accordance with the legal regulations in a special council minute book. 7. The minutes shall be approved by the board of directors itself at the end of the meeting or immediately afterwards, unless the immediacy of the meetings does not allow it, in which case they shall be approved at a later session. 8. In order to facilitate the execution of agreements and, if necessary, their submission to the public, the minutes may be partially approved, including, in each of the approved parts, one or more agreements. 9. When the directors or the secretary express concerns about any proposal or, in the case of the directors, about the progress of Auricoin Bank and about proposals they consider contrary to the corporate interest or to the interest of the members not represented on the board, such concerns shall be recorded in the minutes of the request of the person expressing them. Title 6. Appointment and Removal of Directors. Article 19. Appointment of Directors. 1. The directors will be appointed by the General Council of Partners or by the Board of Directors in accordance with the provisions contained in the law and in the bylaws. 2. Proposals for the appointment and re-election of directors submitted by the Board of Directors for the consideration of the General Assembly of Members. The appointment agreements adopted by said body by virtue of the co-optation powers that it has legally attributed will be submitted, in any case, to the director selection policies that the Board has approved from time to time and must be preceded by A. The corresponding proposal of the Appointments and Remuneration Committee in the case of independent directors, and B. The report of the Appointments and Remuneration Committee in the case of the remaining directors. 3. The proposal referred to in Section 2A above must in any case be accompanied by a justifying report from the Board of Directors in which the competence, experience, and merits of the proposed candidate are assessed, which will be attached to the minutes of the Board, general members, or the Council itself. 4. When the Board departs from the proposals for the Appointments and Remuneration Committee, it must state the reasons for its action and record those reasons in the minutes. 5. Auricoin Bank will provide the necessary support so that new directors can acquire a quick and sufficient knowledge of Auricoin Bank, as well as its corporate governance rules, and may establish orientation programs for this purpose. In the same way, it will also offer the directors knowledge update programs when circumstances make it advisable. 6. Directors who form part of the board of Auricoin Bank or more than 6 boards of directors of commercial companies may not be appointed. For these purposes, those boards of which he is a part as proprietary director proposed by Auricoin Bank or by any company of its group, nor those who do not imply his own and true dedication to a commercial business will not be counted. 7. The board will ensure that the director selection procedures favor diversity of gender, experience, knowledge, and do not suffer from implicit biases that make the selection of female directors difficult, ensuring that Auricoin Bank deliberately seeks out and includes among potential candidates women who meet the professional profile sought. 8. When a member of the Board of Directors is appointed Chief Executive Officer or is assigned executive functions by virtue of another title, it will be necessary for a contract to be entered into between him and Auricoin Bank, which must be previously approved by the Board of Directors with the vote favorable of 2/3 of its members. The affected director must abstain from attending the deliberation and from participating in the vote. The approved contract must be included as an annex to the minutes of the session. Article 20. Appointment of external directors. 1. The Board of Directors comments with the Appointments and Remuneration Committee within the scope of its powers. It will ensure that the proposal of candidates that it submits to the General Assembly of Members for the appointment as directors, and the appointment that it makes directly to cover vacancies in exercises of their powers of co-option. They fall on honorable, suitable people of recognized solvency, competence, and experience, and must exercise extreme rigor in relation to those calls to fill the positions of independent director provided for in Article 10 of these regulations. 2. Independent directors will be considered those who, appointed in consideration of their personal and professional conditions, can carry out their duties without being conditioned by relationships with Auricoin Bank, its significant partners, and its executives. 3. In particular, they may not be proposed or appointed as independent directors who a. have been employees or executive directors of group companies unless 3 or 5 years, respectively, have elapsed since the termination of that relationship. b. Receive from Auricoin Bank any amount or benefit for a concept other than director remuneration, unless it is not significant for the director. Dividends or pension supplements received by the director due to his previous professional or employment relationship will not be taken into account for the purposes of the provisions of that section, provided that such supplements are unconditional and consequently Auricoin Bank satisfies them, cannot in a discretionary way suspend, modify, or revoke without the breach of obligations being mediated. c. Whether they are or have been during the last 3 years a partner of the external auditor or person responsible for the audit report, whether it is the audit during said period of Auricoin Bank. d. Are executive directors or senior managers of a different company in which an executive director or member of the management team of Auricoin Bank is an external director. e. Maintain or have maintained during the last year a significant business relationship with Auricoin Bank, either on their own behalf or as a significant shareholder, director or senior management of an entity that maintains or would have maintained such relationship. Business relationships shall be considered as those of a provider of goods or services, including financial ones, and that of an advisor or consultant. f. Are significant partners, executive directors, or senior managers of an entity that receives or has received during the last 3 years donations from Auricoin Bank. Those who are more patrons of a foundation that receives donations will not be considered included in this letter. g. They are spouses, people linked by a similar emotional relationship, or relatives up to the 5th degree of an executive director or member of the management team of Auricoin Bank. h. They have not been proposed either for appointment or renewal by the Appointments and Remuneration Committee. I. They have been directors of Auricoin Bank for a period of more than 12 years in accordance with these regulations. J. They are with respect to any significant shareholder or represented on the board in any of the cases indicated in letters A, E, F, or G of this section. In the case of the kinship relationship indicated in letter G, the limitation will apply not only with respect to the shareholder but also with respect to the proprietary directors in Auricoin Bank. Proprietary directors who lose such status as a result of the sale of their participation by the shareholder they represented may only be re-elected as independent directors when the shareholder they represented up to that moment had sold all of their shares in Auricoin Bank. K. A director who holds a shareholding in Auricoin Bank may have the status of independent, provided that he satisfies all the conditions established in this section and, in addition, his participation is not significant in accordance with the applicable regulations. Article 21. Term of office. 1. The directors will exercise their position during the term established by the statutes, as long as the General Assembly of Members does not agree to their separation or resign from their position. 2. Directors may be re-elected one or more times for periods of the same duration. In the case of independent directors, they may be re-elected, but provided that they do not remain as such for a continuous period of more than 12 years. 3. The vacancies that occur may be covered by the Board of Directors by co-option, in accordance with the regulations on an interim basis until the meeting of the first General Assembly of Members that is held, which may confirm the appointments, elect the people who must replace non-ratified directors, or cancel vacancies. 4. The appointment of the directors will expire when, after the deadline, the next General Assembly of Members has been held, or the legal term for holding the board that must resolve on the approval of the accounts of the previous year has elapsed. Article 22. Resignation and termination of directors. 1. The directors will resign from their position when the period for which they were appointed has elapsed, when so agreed by the General Assembly of Members in use of the powers that correspond to them and when they present the resignation or demission. 2. The directors must place their position at the disposal of the Board of Directors and formalize if the latter considers it appropriate the corresponding resignation in the following cases. A. When they are involved in any of the cases of incompatibility or prohibition provided for in general provisions and in the bylaws. B. When due to events attributable to the director in his capacity as such, serious damage to Auricoin Bank and social reputation has been caused, or the commercial and professional honor necessary to be a director of Auricoin Bank is lost. C. When they cease to hold the executive positions to which their appointment as director is associated in their case. D. When they are prosecuted for an allegedly criminal act or are subject to a disciplinary file for serious or very serious misconduct instructed by the authorities. And E. When their permanence on the board could put at risk the interests of Auricoin Bank, of Auricoin money, or when the reasons for which they were appointed disappear. In particular, in the case of external proprietary directors, when the shareholder whom they represent sells or transfers their participation in whole or in part, with the consequence of losing the status of significant or sufficient to justify the appointment. 3. In any of the cases indicated in the previous section, the Board of Directors, in view of the specific circumstances, may require the director to resign from his position and, where appropriate, propose his removal to the General Assembly of Members, without prejudice to the communication of the termination as a relevant event. The board will report the reason for the termination in the annual corporate governance report. 4. The directors affected by proposed termination shall abstain from taking part in the deliberations and votes that deal with them. 5. The board of directors may only propose the removal of an independent director before the expiration of the statutory period, when just cause appreciated by the board of directors after a report from the Appointments and Remuneration Committee. In particular, it will be considered that there is just cause when the director takes up new positions or contracts new obligations that prevent him from dedicating the necessary time to the performance of the functions of the position of director, fails to fulfill the duties inherent to his position, or incurs in any of the circumstances that make him lose his independent status. Such separation may also be proposed as a result of takeover bids, mergers, or other similar corporate operations that determine a significant change in the structure of the capital stock of Auricoin Bank, when such changes in the structure of the board are brought about by the aforementioned proportionality criterion in Article 10.2 of these regulations. 6. When a director leaves his position before the end of his term due to the resignation or for any other reason, he must explain the reasons for these in a letter that he will send to all the members of the board. The reasons cited there will be mentioned in the annual report of the corporate governance. Title 7. Directors' Information. Article 23. Powers of Information and Inspection. 1. The director has the duty to diligently inform himself about the progress of Auricoin Bank. For this, the director may request information on any aspect of Auricoin Bank and examine its books, records, documents, and other documentation. The right to information extends to investee companies whenever possible. 2. The exercise of the powers of information will be channeled previously through the director of the board of directors, who will send the request to the appropriate interlocutor who proceeds in Auricoin Bank. If it is confidential information in the opinion of the director, the latter will warn the director who requests and receives it of this circumstance, as well as his duty of confidentiality in accordance with the provisions of the law and in these regulations. Article 24. Expert Assistance. In order to be assisted in the exercise of their functions, external directors may 1. Request the hiring at the expense of Auricoin Bank of legal, accounting, technical, commercial, financial advisors, or other experts. The assignment must necessarily deal with specific problems of a certain importance and complexity that arise in the performance of the position. 2. The request to contract will be channeled through the director of the board of directors of Auricoin Bank, who may subject it to the prior authorization of the board of directors, which may be denied when there are causes that justify it, including the following circumstances. A. That it is not necessary for the full performance of the functions entrusted to external directors. B. That its cost is not reasonable in view of the importance of the problem and the assets and income of Auricoin Bank. C. That the technical assistance that is collected can be adequately provided by experts and technicians from Auricoin Bank. Or D. That it may pose a risk to the confidentiality of the information that must be handled and provided to the expert. Title 8. Duties of the Director. Article 25. General Obligations. In the performance of their duties, the director will act in good faith and with the diligence of an orderly business person and with the loyalty of a faithful representative, acting in good faith and in the best interest of Auricoin Bank. The standard of diligence in an orderly business person will be understood to be met when the director has acted in good faith without personal interest in the matter under decision, with sufficient information and in accordance with an appropriate decision procedure. 1. Notwithstanding the obligation to comply with the duties imposed by the law of banking companies and the corporate bylaws, the director is obliged in particular to a. Adequately prepare the meetings of the board and, where appropriate, of the delegated bodies to which it belongs, and must be diligently informed about the progress of Auricoin Bank and about the matters to be discussed in said meetings. B. Attend the meetings of the Board of Directors and actively participate in the deliberations in order for their criteria to effectively contribute to the decision-making process. In the event that for justified cause he cannot attend the sessions to which he has been summoned, he must instruct the director who is to represent him. C. Carry out any specific task entrusted to it by the Board of Directors or any of its delegated and/or advisory bodies and is reasonably included in its commitment of dedication. D. Report to the board of the competent body of Auricoin Bank of any irregularities in the management of Auricoin Bank of which he may have heard. E. Urge the people with the capacity to convene to call an extraordinary meeting of the board or include in the agenda of the first meeting to be held the points that they deem appropriate. F. Oppose agreements contrary to the law or the bylaws or the corporate interest. Request the record of its position in the minutes when it deems it more convenient for the protection of the corporate interest and promote the challenge, where appropriate, of such agreement. And G. Provide their strategic vision, as well as concepts, criteria, and innovative measures for the optimal development and evolution of Auricoin Bank business. Article 26. Duty of confidentiality and non-public information. The director, even after leaving his functions, will keep secret the deliberations of the Board of Directors and the delegated bodies of which he is part, and in general will refrain from revealing the information, data, reports, or antecedents to which he has had access in the exercise of their position, even when they have ceased to do so, as well as to use them for their own benefit or that of any other third party when it could have harmful consequences for the social interest. 1. Exceptions from the duties referred to in this article are those cases in which the laws allow their communication or disclosure to third parties, or that, where appropriate, are required or have to be referred to the respective supervisory authorities, in which case the transfer of information must comply with the provisions of the laws. 2. Without prejudice to the obligations that correspond to the directors in matters of privileged information of Auricoin Bank in the terms referred to in the legislation issued by the country's authority on the crypto assets market, the directors will refrain from using any non-public information for their own benefit or third party. Article 27. Non-competition obligation. 1. The director may not carry out on his own account or on behalf of another, directly or indirectly, any activity that constitutes direct and effective competition, be it current or potential, with which the Auricoin Bank develops or that in any other way places him in permanent conflict with the interests of Auricoin Bank. The functions and positions that may be held in subsidiaries or entities in which Auricoin Bank have an investee are safe. 2. The non-competition obligation provided for in the previous section may be waived by Auricoin Bank at the proposal of the Board of Directors and by agreement of the General Assembly of Members when, in light of the circumstances, no damage can be expected for Auricoin Bank, or whoever can waive will be compensated by the benefits that are expected to be obtained from the waiver. Any exception will require a prior report from the Audit and Compliance Committee. 3. For these purposes, the directors must communicate the direct or indirect participation that they had in the capital of a company with the same, analogous or complementary type of activity to the one that constitutes the corporate purpose, and will also communicate the positions or functions they exercise therein, as well as the performance of the same, analogous or complementary type of activity that constitutes the corporate purpose of Auricoin Bank on its own account or for someone else. This information will be included in the annual corporate governance report and in the annual report. Article 28. Conflict of interest. 1. It will be considered that there is a conflict of interest in those situations in which the interest of Auricoin Bank and the personal interest of the director collide, directly or indirectly. There is personal interest of the director when the matter affects him or a related person. 2. For the purposes of these regulations, persons related to the directors will be considered as those determined by this document. 3. Without prejudice to the provisions of the duty to avoid situations of conflict of interest established in the law, situations of conflict of interest will be governed by the following rules. A. The director will endeavor to avoid situations that may represent a conflict of interest between Auricoin Bank and the director or their related parties. B. In any case, the director must notify the Board of Directors of the existence of conflicts of interest when they become aware of them. C. In any case, the director must abstain from attending and intervening in the deliberations and voting that affect matters in which he is personally interested. In this sense, the votes of the directors affected by the conflict and who have to abstain will be deducted for the purposes of calculating the majority of votes that is necessary. D. In any case, the situations of conflict of interest in which the directors find themselves will be the object of information in the annual corporate governance report and in the annual report. 4. The agreements or decisions that affect him in his capacity as director, such as his appointment or revocation for positions in the Board of Directors or others of similar significance, will be excluded from the above obligation to abstain. 5. The director may not directly or indirectly carry out professional or commercial transactions with Auricoin Bank, unless he informs in advance of the conflict of interest and the Board of Directors approves the transaction, following a report from the Audit and Compliance Committee. Article 29. Use of corporate assets. 1. The directors may not use the assets of Auricoin Bank that represent more or equal to 5% of the capital of Auricoin Bank without the prior written authorization issued by the Board of Directors. 2. The director may not make use of the assets of Auricoin Bank, including the confidential information of Auricoin Bank, nor use his position in Auricoin Bank to obtain an equity advantage unless he has paid adequate consideration. 3. Exceptionally, the director may be exempted from the obligation to pay the consideration, but in that case, the patrimonial advantage will be considered indirect remuneration and must be authorized by the board, following a report from the Appointments and Remuneration Committee. If the advantage is received as a shareholder, it will only be appropriate if the principle of equal treatment of the partners is respected. The authorization may be granted provided that the independence of the members who grant it with respect to the dispensed director is guaranteed. In addition, it will be necessary to ensure the harmlessness of the authorized operation for the social assets or, where appropriate, its performance under market conditions and the transparency of the process. Article 30. Business opportunities. 1. The director may not take advantage of, for his own benefit or that of persons related to him, a business opportunity of Auricoin Bank within its ordinary scope of action, unless the investment or operation had been previously offered to Auricoin Bank, that it had desisted from exploiting it without the influence of the director, and that the use of the operation by the director was authorized by the board of directors or by the General Assembly of Members, where appropriate, following a report from the Audit and Compliance Committee. 2. For the purposes of the previous section, a business opportunity is understood to be any possibility of carrying out an investment or commercial operation that has arisen or has been discovered in connection with the exercise of the position by the director, or through the use of means and information of the Auricoin Bank, or under circumstances such that it is reasonable to think that the third party's offer was actually addressed to Auricoin Bank. 3. Likewise, the director must refrain from using the name of Auricoin Bank and from invoking his condition as director of Auricoin Bank to carry out operations on his own account for related persons. Article 31. Indirect operations. The director violates his fidelity obligations towards Auricoin Bank if, knowing it in advance, he allows or does not reveal the existence of operations carried out by the related persons that had not been subjected to the conditions and controls provided in the previous articles. Article 32. Duties of information. 1. The director must notify Auricoin Bank of the shares of the same held directly or indirectly through the related parties, all in accordance with the provisions of the Internal Code of Conduct in matters relating to the cryptoactive markets. 2. The director must also inform Auricoin Bank of the positions and activities that he performs or acts in other companies, and in general of his other professional obligations, and of any fact or circumstance that could interfere with the dedication required or be relevant for his performance as administrator of Auricoin Bank. 3. The director must inform the Auricoin Bank of those circumstances that affect him and may harm the Auricoin money or the reputation of the Auricoin Bank, especially of the criminal cases in which they appear as defendants and of their important procedural vicissitudes, reporting to the board of all these in the annual corporate governance report. After examining the situation, the board may require the directors to resign, a decision that must be followed by the director. 4. The director must provide Auricoin Bank with an email address as well as a mobile phone number, so that the meetings of the board of directors can be convened through these channels, if so desired, and provided, where appropriate, the corresponding information. Title 9. Remuneration of Directors. Article 33. Remuneration of Directors. 1. The members of the Board of Directors will receive, in their capacity as such, a remuneration in Auricoin money, whose maximum annual amount for the entire Board of Directors will be determined by the General Assembly of Members. This remuneration of the directors will consist of a fixed monthly allowance and allowances for attending the meetings of the Board of Directors and its committees. The maximum amount of remuneration to be paid by Auricoin Bank to its directors for such concepts will be that determined for this purpose by the General Assembly of Members, which will remain in force until its modification is agreed. 2. The Board of Directors, within the limit set by the General Assembly, will set the specific amount to be received by each of the directors each year, taking into account the functions and responsibilities attributed to each director and the other objective circumstances that the Board of Directors consider relevant, including, among others, A. Whether or not he belongs to delegated bodies of the Council. B. The positions he occupies in the same or in general. C. His dedication to the task of administration or to the service of Auricoin Bank. 3. The remuneration of the directors must in any case keep a reasonable proportion with the importance of Auricoin Bank, the economic situation it had at all times, and the market standards of comparable companies. The remuneration system established must be aimed at promoting the profitability and long-term sustainability of Auricoin Bank and incorporate the necessary precautions to avoid the excessive assumption of risks and the reward of unfavorable resorts. 4. The remuneration derived from belonging to the Board of Directors will be compatible and independent from the other professional or labor perceptions that may correspond to the directors for the performance of executive or advisory tasks other than those of supervision and collegiate decision inherent to their condition as directors, which will be subject to the legal regime that is applicable. 5. The executive directors will receive, for the performance of the executive functions delegated or entrusted by the Board of Directors, the remuneration that the Board itself determines. This remuneration will be adjusted to the remuneration policy for directors approved by the Board and will be reflected in the corresponding contract that will be signed between the director and Auricoin Bank. In particular, and without limitation, the remuneration provided for in this section and subject to the aforementioned remuneration policy may consist of fixed salaries, variable remuneration based on the achievement of business, corporate and/or personal performance objectives, compensation for termination of the director for reasons other than the breach of their duties, pensions, insurance, forecast system, deferred remuneration items, and remuneration formulas consisting of the delivery of Auricoin money established for those members of the Board of Directors who fulfill executive functions. 6. Payments for termination of the contract shall not exceed an established amount equivalent to 2 years of the total annual remuneration and shall not be paid when the termination of the contract is caused by inadequate performance and until Auricoin Bank has been able to verify that the director has met previously established performance criteria. 7. Regarding external directors, the Board will adopt all measures within its power to ensure that their remuneration, including that which they may receive as members of the committees, meets the following criteria. A. The external director must be paid based on their effective dedication, qualification, and responsibility. And B. The amount of the remuneration of the external director must be calculated in such a way that it offers incentives for their dedication, but does not constitute an obstacle to their independence of criteria. 8. The directors will have the right to pay the justified travel expenses they have incurred to attend the meetings of the Board of Directors or its committees. 9. Auricoin Bank may contract civil liability insurance for its directors. 10. The remuneration of external directors and executive directors will be recorded in the report individually for each director. 11. Together with the annual corporate governance report, the Board of Directors must prepare and disseminate an annual report on the remuneration of the directors, which will include complete, clear, and understandable information on the remuneration policy of Auricoin Bank approved by the Board for the year ongoing, as well as, where applicable, the one planned for future years. It will also include a global summary of how the remuneration policy was applied during the year, as well as a detail of the individual remuneration accrued by each of the directors. This report will be disseminated and submitted to a consultative vote and a separate item on the agenda of the ordinary General Assembly of Members. 12. Auricoin Bank will encourage all its members, in particular the institutional members, to attend the General Assemblies of Members and to make prudent use of their votes when it comes to the remuneration of directors. Title 10. Council Relations. Article 34. Relations with Partners. 1. The Board of Directors may request at any time from the entity in charge of the record of book entries the data necessary for the identification of the Auricoin Bank members, including the addresses and means of contact available to them to allow communication with them. For these, the directors must be periodically informed of the movements in the shareholding and of the opinion that the significant members, investors, and rating agencies have about Auricoin Bank. 2. The Board of Directors will arbitrate the appropriate channels to know the proposals that the members may formulate in relation to the management of Auricoin Bank. 3. The Board, through some of its directors and with the collaboration of the members of the management team that it deems pertinent, may organize informative meetings on the progress of Auricoin Bank and its group or other aspects of interest for members who reside in locations with most relevant cryptoactive markets in the country and abroad. In its relations with the members, the Board of Directors will guarantee equal treatment, simultaneously facilitating the presentations used in the informational meetings and being published on the Auricoin Bank website. 4. The Board of Directors will also establish adequate mechanisms for the exchange of regular information with institutional investors that are part of the shareholders of Auricoin Bank. In no case may the relations between the Board of Directors and said partners be translated into the delivery to them of any information that could provide them with a privileged or advantageous situation with respect to the other partners. 5. The Board of Directors will promote the informed participation of the members in the General Assemblies of Members and will adopt whatever measures are appropriate to facilitate that the General Assembly of Members effectively exercise the functions that are proper to it in accordance with the law and the bylaws. In particular, the Board of Directors will adopt the following measures. A. It will endeavor to make available to the members prior to the Assembly all the information that is legally required and all that, without being it, may be of interest and be reasonably supplied. B. It will respond with the utmost diligence to requests for information made by the members prior to the General Assembly of Members. C. It will respond with equal diligence to the questions asked by the members on the occasion of the celebration of the General Assembly of Members. And D. It will ensure that the matters proposed to the Assembly are voted in an orderly and separate manner, giving the members the opportunity to intervene to express their opinion on each of the questions submitted to the vote. Article 35. Relations with the cryptoactive markets. 1. The Board of Directors, through the communications of relevant events to the authorities of the country and the corporate website, will inform the public as soon as possible about all privileged information in the terms established in the legislation on Auricoin money. In particular, the Board of Directors will inform the public as soon as possible about A. Substantial modifications to the governance rules of Auricoin Bank, and B. Changes in the composition of the rules or organizations and operation of the Board and its committees, or in the function and positions of each director within Auricoin Bank, as well as any other relevant modification in the corporate governance system. 2. The Board of Directors will adopt the necessary measures to ensure that the semi-annual, quarterly, and any other financial information that is made available to interested persons is prepared in accordance with the same principles, criteria, and professional practices used to prepare the annual accounts, and that enjoys the same reliability as the latter. 3. The information obligations will be fulfilled by any technical, computer, or telematic means without prejudice to the rights that correspond to the shareholder to request information in printed form. Article 36. Relations with the external auditor. 1. The Board of Directors will establish an objective, professional, and continuous relationship with the external auditor of Auricoin Bank, respecting their independence to the maximum. 2. The relationship to which the previous number refers will normally be channeled through the Audit and Compliance Committee. 3. The Board of Directors will publicly report the global fees paid by Auricoin Bank to the auditing firm, both for auditing services and for services other than auditing. 4. The Board of Directors will publicly report the global fees paid by Auricoin Bank to the auditing firm, both the auditing services and for services other than auditing. Title 11. Committees of the Board. Article 37. The Delegated Committee. 1. The Board of Directors may appoint a delegated committee from among its members, which will include the director and, if there is one, the CEO. 2. In the absence of a specific rule, the provisions of these regulations relating to the operation of the Board of Directors, and in particular regarding the calling of meetings, delegation of representation, are not incompatible with its nature in favor of another director, constitution, sessions of a universal nature, regime for adopting resolutions and holding votes in writing and without a session. 3. The powers of said committee will be those that in each case are delegated by the Board within the limits of the law, the bylaws, and these regulations. 4. If a delegate committee is appointed, it must inform the Board of the main matters discussed and the decisions on them at its sessions. 5. The Director and the Secretary of the Executive Committee will be those who, in turn, are the Secretary of the Board of Directors. The participation structure of the different categories of directors will be similar to that of the Board itself. Article 38. The Audit and Compliance Committee. 1. The Board of Directors will permanently set up an Audit and Compliance Committee that will be made up of a minimum of 3 directors and a maximum of 5 appointed by the Board of Directors from among its external directors. The majority of the members of the Audit Committee will be independent. 2. The members of the Audit and Compliance Committee, and especially its director, shall be appointed taking into account their knowledge and experience in accounting, auditing, or risk management. For this purpose, both the knowledge and professional experience accumulated in the performance of functions directly associated to such matters, and those knowledge and experience resulting from the performance of management and executive functions and responsibilities that, among others, significantly affect the aforementioned matters, for example, as managing directors, chief executives, or senior managers with responsibility for supervision and control over the financial areas, accounting, risk management, etc., shall be positively valued. 3. The Audit and Compliance Committee shall be responsible in any case without prejudice to any other tasks that may be assigned to it at any time by the Board of Directors. A. Inform the General Assembly of members on the questions that arise in relation to those matters that are within the competence of the committee. B. Supervise and review the process of preparation and presentation of the mandatory financial information that, in accordance with what the board must supply to the markets and their supervisory bodies, and in general, monitor compliance with the legal requirements in this matter as appropriate. Delimitation of the consolidation perimeter and the correct application of general accepted accounting principles, as well as informing the proposals for modifying accounting principles and criteria suggested by management. C. Supervise and periodically review the effectiveness of the internal control of Auricoin Bank and risk management systems, financial and non-financial, including tax, checking the adequacy and integrity of the same, and propose the selection, appointment, re-election, and removal of those responsible. Propose the budget for said services. Approve the orientation and its work plans, ensuring that its activity is mainly focused on the relevant risk of Auricoin Bank, and verify that the members of the management team take into account the conclusions and recommendations of their reports, as well as discussing with the account auditors of Auricoin Bank the significant weaknesses of the internal control system that may be detected in the development of the audit. D. Coordinate the process of reporting non-financial and diversity information in accordance with applicable regulations and international reference standards. E. Ensure the independence of the unit that assumes the internal audit function. Propose the selection, appointment, re-election, and removal of the person in charge of the internal audit service. Propose the budget for this service. Approve the orientation and its work plans, ensuring that its activity is mainly focused on the relevant risk of Auricoin Bank. Receive periodic information about his activities and verify that senior management takes into account the conclusions and recommendations of its reports. F. Submit to the Board of Directors the proposals for the selection, appointment, re-election, and replacement of the external accounts auditors, as well as their contracting conditions, and regularly collect information from them on the audit plan and its execution, in addition to preserving their independence in the exercise of their functions. G. Establish the appropriate relationships with the external auditors of accounts to receive information on those matters that may put their independence at risk for examination by the committee, and any others related to the process of carrying out the audit of accounts, as well as those other communications provided for in the legislation on account auditing and in the auditing standards. In any case, they must receive annually from the external auditors the declaration of their independence in relation to the entity or entities linked to it directly or indirectly, as well as information on the additional services of any kind provided and the corresponding fees received from these entities by the aforementioned external auditors, by the persons or entities linked to them, in accordance with the provisions of the legislation on account auditing. In the event of the resignation of the external auditor, it shall examine the circumstances that may have caused it, and shall supervise that Auricoin Bank communicates as a relevant fact to the respective authority the change of auditor, and accompanies it with a statement on the possible existence of disagreements with the outgoing auditor, and, if they have existed, of their contempt. H. To issue annually, prior to the issuance of the audit report, a report expressing an opinion on the independence of the auditors. This report shall in any event contain an assessment of the provision of the additional services referred to in the previous point, individually and as a whole, other than the statutory audit and in relation to the independence regime or the audit regulations. I. Serve as a communication channel between the Board of Directors and the auditors, evaluate the results of each audit and the responses of the management team to their recommendations, and mediate in cases of discrepancies between the former and the latter in relation to the principles and criteria applicable in preparation of financial statements. The committee will ensure that the external auditor holds an annual meeting with the full board of directors to inform them about the work carried out and about the evolution of the accounting and risk situation of Auricoin Bank. J. Inform the board of directors in advance on all matters provided for in the law, the bylaws, and the regulations of the board of directors, and in particularly on 1. The financial information that Auricoin Bank must make public periodically. 2. The creation or acquisition of shares in special purpose entities or domiciled in countries or territories that are considered tax havens. 3. Supervise compliance with the regulations regarding related transactions with directors or significant partners or those represented on the board. In particular, it will inform the latter about said related party transactions and, in general, about transactions that involve or may involve conflicts of interest for the purposes of their approval, and will ensure that the information about them required by law is communicated to the market. 4. Monitor compliance with internal codes of conduct, in particular the Code of Conduct in Banking. And 5. Review the corporate social responsibility policy, ensuring that it is oriented to the creation of value, monitoring the strategy, corporate social responsibility practices, and evaluating its degree of compliance. K. Supervise the communication and relationship strategy with partners, investors, including small and medium partners, and other stakeholders. L. Establish an internal mechanism that allows employees to communicate confidentiality and, if deemed appropriate, anonymously irregularities of potential importance, especially financial and accounting, that they notice within Auricoin Bank. M. Prepare and keep updated a statement of ethical values of Auricoin Bank assets regarding the reliability of financial information and compliance with the applicable regulations, which will be approved by the Board of Directors and communicated to all levels of the organization. N. Establish procedures to monitor that the principles of integrity and professional ethics are respected, as well as measures to identify and correct deviations from these values within the organization. O. It will be informed about the structural and corporate modification operations that Auricoin Bank plans to carry out for its analysis and prior report to the Board of Directors on its economic conditions, its accounting impact, especially in its case on the proposed exchange equation, and P. Any others that are attributed to it by virtue of the law and other regulations applicable to Auricoin Bank. 4. The Audit and Compliance Committee will be called by the Director of the Committee, either on his own initiative or at the request of the Director of the Board of Directors or 2 members of the committee itself. The call will be sent by letter, email, or any other means that allows proof of receipt. 5. In any case, the Audit and Compliance Committee will convene and meet at least quarterly in order to review the periodic financial information that, in accordance with the requirements issued by the authorities for this type of company, as well as the information that the Board of Directors must approve and include in its annual public documentation. 6. The director of the Audit and Compliance Committee will be appointed from among the independent directors that are part of it. 7. The director must be replaced every 3 years and may be re-elected after a period of 1 year has elapsed since his termination. 8. Likewise, the committee will designate a secretary and may appoint a vice secretary, both of whom may not be members of the committee. In the event of not making such appointments, those of the board will act as such. 9. The Audit and Compliance Committee will be validly constituted when the majority of its members attend, present, or represented. Resolutions will be adopted by a majority of concurrent members present or represented. 10. Minutes will be drawn up of the resolutions adopted of each sessions, which will be reported to the plenary session of the board, sending or delivering a copy of the minutes to all members of the board. 11. The Audit and Compliance Committee will promote the availability of a unit that assumes that internal audit function that ensures the proper functioning of the information and internal control systems, and that functionally depends on the non-executive director of the board or that of the Committee on Audit. This unit will present to the Audit Committee its annual work plan, will report directly on incidents that arise in its development, and will submit an activity report at the end of each year. 12. The Audit and Compliance Committee will prepare an annual report on its operation, highlighting the main incidents that have arisen, if any, in relation to its functions. In addition, when the Audit and Compliance Committee deems it appropriate, it will include in said report proposals to improve the governance rules of Auricoin Bank. 13. The members of the management team or staff of Auricoin Bank will be obliged to attend the sessions of the Audit and Compliance Committee and to provide their collaboration and access to the information at their disposal when the committee so requests. The committee may also require the attendance at its sessions of the account auditors of Auricoin Bank. 14. When deemed necessary for the proper fulfillment of its functions, the Audit and Compliance Committee may seek advice from external experts, bringing this circumstance to the attention of the Secretary or Vice Secretary of the Board, who will be in charge of hiring the corresponding services. 15. In the absence of a specific rule, they will be applicable to the Audit and Compliance Committee, insofar as the provisions of these regulations relating to the operation of the Board of Directors are not incompatible with their nature. Article 38 B. The Strategy Commission. 1. The Board of Directors may set up a strategy committee made up of a minimum of 3 and a maximum of 5 directors, which will be made up mostly of independent directors or other external directors. The Board of Directors will appoint the members of the Strategy Committee. 2. The Board of Directors shall appoint its director from among its members of the Strategy Committee, who must in all cases be an independent director, and its secretary shall be the secretary of the board or, in its absence, the person appointed by the committee itself, without the secretary necessarily having to be a member of the committee. 3. It will be endeavored that the members of the Strategy Committee have knowledge, skills, and experience appropriate to the functions they are called to perform. 4. In any case, they will be the responsibility of the Strategy Committee without prejudice to any other task that may be assigned at any time by the Board of Directors or by its director. A. Evaluate and propose to the Board of Directors the strategic lines of Auricoin Bank and its group in the medium and long term. B. Advise, inform, and provide support to the Board of Directors in the framework of the periodic monitoring of the implementation of the strategy of Auricoin Bank and its group, continuously assessing and, among other factors, its suitability to its sector of activity, the conditions and challenges presented by the markets in which it must operate, the applicable regulatory framework, and group's resources, capacities, and development and growth potential. C. Assess the convenience and, where appropriate, purpose new investments, divestments, and development plans or restructuring processes that are strategic for Auricoin Bank. D. Facilitate collaboration and coordination with the group management in all the above matters. 5. The Strategy Commission will meet as often as determined by its members or as many times as necessary, in the opinion of its director. The committee meetings will be called by its director, either on her own initiative or at the request of the director of the board of directors or two members of the committee itself. The call will be issued in the same way established for the call of the board in the regulations. 6. The Strategy Committee will be validly constituted when the majority of its members attend, present, or represented. Resolutions will be adopted by a majority of concurrent members, present or represented. In the event of a tie, the director of the committee will have a casting vote. 7. The Strategy Committee may summon any of the members of the management team or staff of Auricoin Bank and its group, who will be obliged to attend the committee sessions and to collaborate with them. In addition, when the members of the committee deem it necessary for the proper fulfillment of their functions, the committee may seek and hire the advice of external experts. 8. The board of directors will determine the eventual remuneration supplements that, if applicable, may be attributed to the members of the Strategic Committee due to their belonging to it and the functions performed in it. 9. Minutes will be drawn up of the resolutions adopted at each session, which will be reported to the full board. The minutes will be available to all members of the board in the secretariat of the same, but will not be sent or delivered for reasons of discretion, unless the director of the committee provides otherwise. 10. In the absence of a specific additional rule or regulation, they will be applicable to the Strategy Committee insofar as the provisions of these regulations relating to the operation of the Board of Directors are not incompatible with their nature. Article 39. The Appointments and Remuneration Committee. 1. The Board of Directors will establish a permanent Appointments and Remuneration Committee, which will be made up exclusively of external or non-executive directors, mostly independent, in the number determined by the Board of Directors, with a minimum of 3 and a maximum of 5. The Board of Directors will appoint the members of the Appointments and Remuneration Committee. 2. The Appointments and Remuneration Committee will appoint a director from among its members. The director will be an independent director. The director must be replaced every 4 years, being able to be re-elected once a period of 1 year has elapsed since her termination. 3. It will be ensured that the members of the Appointments and Remuneration Committee have adequate knowledge, skills, and experience for the functions they are called upon to perform. For these purposes, both the knowledge and professional experience accumulated in the performance of functions directly associated with said matters, as well as the knowledge and experience that are the result of the performance of management and executive functions and responsibilities that, among others, will be positively valued, significantly affect the aforementioned matters, for example, as CEOs, senior executives, or senior managers with responsibilities for supervision and control over the areas of human resources, corporate governance, remuneration policies, etc. 4. The Appointments and Remuneration Committee shall be competent in any case without prejudice to any other duties that may be assigned to it at any time by the Board of Directors. A. Evaluate the skills, knowledge, and experience required on the Board of Directors. For these purposes, the committee will define the functions and skills necessary for the candidates who must fill each vacancy and will evaluate the time and dedication required for them to effectively carry out their duties. B. Submit to the Board of Directors the proposals for the appointment of independent directors for their appointment by co-option for submission to the decision of the General Assembly of Members, as well as proposals for the re-election or removal of said directors by the General Assembly of Members. C. Report the proposals for the appointment of the remaining directors for their appointment by co-option for submission to the decision of the General Assembly of Members, as well as the proposals for the re-election or removal of said directors by the General Assembly of Members. D. Inform the Board of Directors about the appointment, re-election, and dismissal of the internal positions of the Board of Directors of Auricoin Bank. Director and Vice Director, Coordinating Director, Secretary and Vice Secretary if applicable. E. Report the proposals for the appointment and removal of senior managers and the basic conditions of their contracts. F. Report to the Board on gender diversity issues and, in particular, ensure that the selection procedures for directors and senior managers do not suffer from implicit biases that hinder the selection of women. In this sense, the committee will establish a representation objective for the sex less represented on the Board of Directors and will prepare guidelines on how to achieve said objective. G. Propose to the Board of Directors A. The remuneration policy for directors and general managers or those who carry out senior management functions, reporting directly to the Board. Committees for CEOs. B. The individual remuneration of the executive directors and the other conditions of the contracts, ensuring their observance. And C. The basic conditions of the contracts of senior managers. H. Analyze, formulate, and periodically review the remuneration policy applied to executive directors and the management team, including remuneration systems with shares and their application, as well as ensuring that it is proportionate to the one paid the other directors and members of the management team and other members of the Auricoin Bank staff. I. Ensure compliance with the remuneration policy established by Auricoin Bank. J. Examine and organize the succession of the Director of the Board of Directors and the Chief Executive of Auricoin Bank and, where appropriate, make proposals to the Board of Directors so that said succession occurs in an orderly and planned manner. K. In general, supervise compliance with the corporate governance rules applicable to Auricoin Bank, including the periodic evaluation of the corporate governance system of Auricoin Bank, in order to fulfill its mission of promoting social interest and take into account, according to appropriate, the legitimate interests of the remaining stakeholders. L. Inform the members of the exercise of their functions attending the General Assembly of Members for this purpose. And M. Assist the Board in preparing the report on the Director's remuneration policy and submit to the Board any other reports on remuneration provided for in these regulations, verifying the information on the remuneration of directors and senior managers contained in the different corporate documents, including the annual report on directors' remuneration. 5. The Appointments and Remuneration Committee will meet as many times as necessary, in the opinion of its director, who must call a meeting whenever the issuance of a report or the adoption of proposals is required, and, in any case, whenever it is convenient for the good performance of their duties. 6. It will be called by the director of the committee either on his own initiative or at the request of the director of the board of directors, or two members of the committee itself. The call will be sent by letter, email, or any other means that allows proof of receipt. 7. The Appointments and Remuneration Committee will be validly constituted when the majority of its members attend, present, or represented. Resolutions will be adopted by a majority of concurrent members, present or represented. 8. Minutes of the resolutions adopted at each session will be drawn up, which will be reported to the plenary session of the Board of Directors. The minutes will be available to all members of the Board of Directors in the Secretariat of the same, but will not be sent or delivered for reasons of discretion unless the director of the committee provides otherwise. 9. The Appointments and Remuneration Committee will prepare an annual report on its operation, highlighting the main incidents that have arisen, if any, in relation to its functions. 10. The members of the Board of Directors of the management team or of the personnel of Auricoin Bank will be obliged to attend the sessions of the Appointments and Remuneration Committee and to provide their collaboration and access to the information available to them when the committee so requests. In addition, when it deems it necessary for the proper fulfillment of its functions, it may seek advice from external experts. 11. In the absence of a specific rule, the provisions of these regulations relating to the operation of the Board of Directors will be applicable to the Appointments and Remuneration Committee insofar as they are not incompatible with its nature. Title 12. Information Policy. Article 40. Annual Corporate Governance Report. 1. The Board of Directors will annually approve an annual corporate governance report of Auricoin Bank with the legally foreseen mentions together with those that, where appropriate, it deems appropriate. In particular, the report must offer a detailed explanation of the structure of the governance system of Auricoin Bank and its operation in practice, including in particular a description of the main characteristics of the internal control and risk management systems in relation to the process of issuing financial information. 2. The annual corporate governance report will be approved prior to the publication of the announcement of the convocation of the ordinary General Assembly of members of Auricoin Bank of the year to which it refers and will be made available to the members together with the rest of the documentation of the General Assembly of members. 3. Auricoin Bank will include the annual corporate governance report in a separate section of the management report. 4. Additionally, the annual corporate governance report will be the object of the publicity provided for in the regulations. In particular, the report will be published as a relevant fact. Article 41. Annual Report of Directors' Remuneration. 1. Together with the annual report on corporate governance, the Board of Directors will prepare and publish an annual report on the remuneration of the directors, which will include the remuneration that the directors receive or should receive in their capacity as such and, where appropriate, by the performance of executive functions. 2. This report will include complete, clear, and understandable information of the directors' remuneration policy applicable to the current fiscal year, as well as a global summary on the application of the remuneration policy during the closed fiscal year and the detail of the individual remuneration accrued by all the concepts for each of the directors in said year. 3. This report will be disseminated and submitted to a vote by the Ordinary General Assembly of Members on a consultative basis and a separate item on the agenda. Article 42. Web page. 1. Auricoin Bank will maintain a web page to attend to the exercise of the members' right to information and to disseminate relevant information on Auricoin Bank to all investors. The website will include the documents and information provided for by law and any others determined by the Board of Directors and at least the following in the terms provided by law. A. The bylaws, which the legislation of each country requires for these banks. B. The regulations of the General Assembly of Members, which require the legislation of each country for these banks. C. The regulation of the Board of Directors. D. The Internal Code of Conduct. E. The annual corporate governance report corresponding to the last financial year closed and to the previous years. F. The composition of the Board of Directors and its committees, identifying its components, their propositions, their condition, and their possible relationships with significant partners of Auricoin Bank. G. The annual accounts, together with the management report and the periodic public information that is sent to the competent authority. H. The information on the call, the agenda, and the proposed resolutions of any ordinary or extraordinary General Council of Members, as well as any relevant information that the members may need to cast their vote. I. Information on the development of the meetings already held by the General Assembly of Members and, in particular, on the agenda, the composition of the General Assembly of Members at the time of its constitution, the agreements adopted stating the number of votes cast, and the meaning of the same in each of the proposals included in the agenda. J. The existing communication channels between Auricoin Bank and the members, and in particular the pertinent explanations for the exercise of the shareholders' right to information, indicating the postal and electronic mail addresses to which they can contact. K. The means and procedures to confer representation in the General Assembly of Members. L. The means and procedures for the exercise of remote voting in the General Assembly of Members, including, where appropriate, the forms to accredit the attendance and the exercise of the vote by proxy and remotely by telematic means. M. Relevant events communicated to the authorities during the current year and the last close year. And N. The period, means of payment to suppliers of Auricoin Bank, and, where appropriate, the measures to be applied in the following year to reduce it until reaching the maximum established in the corresponding regulations. 2. Specifically, within the information regarding the directors that Auricoin Bank makes public through its website, updated information will be included on 1. Their professional and biographical profile. 2. Other boards of directors to which he belongs, as well as other relevant remunerated activities carried out, whatever their nature. 3. Indication of the category of director to which they belong, indicating, in the case of proprietary directors, the shareholder they represent or with whom they have ties. 4. The date of their first appointment as director of Auricoin Bank, as well as of subsequent re-elections. 5. The shares of Auricoin Bank and options on them of which it is the holder. 3. The Board of Directors may agree to modify, delete, or transfer the website. Said agreement must be reported to the competent authority and notified to all members, and in any case it will be published in the corresponding registry and on the website itself that has been agreed to modify, transfer, or delete during the 30 days after the insertion of the agreement. Title 13. Entry into force. Article 43. Entry into force. The regulation is valid indefinitely and will come into effect on the day the Auricoin Virtual Bank is installed in any country in the world. End.